Hello, dear students. Today, after completion of fundamental rights under Article 25 and 26, I'm going to take another provision which is going to be covered under Article 29 and 30 of the Indian Constitution. All of you know that Article 29 and 30 confers fundamental rights fundamental rights especially related to the cultural and educational rights. It's Article 29, Clause 1, which says that any section of the citizens residing in the any part of the country or any part of India having distinct language, script, and culture of its own has the fundamental rights to conserve the same. One thing must be noted that Article 29, Clause 1 does not refer to any religion, even though marginal note of article mention interest of minority. Here, according to Article 29, Clause 2, which says that admission is not to be denied to any citizen into any educational institutions maintained by the state or aided by the state funds on the ground of religion, race, caste, language, or any of them. Means that the educational institutions which are receiving the aids, getting the aids from the state government or are being maintained by the state government, they could not deny the admission to their education institutions on the ground of religion, race, caste, language, or any of them. This provision guarantees the fundamental rights of citizens as an individual, irrespective of its community or religion to which he belongs. Now, what is the scope of Article 29, Clause 1? The scope of Article 29, Clause 1 has been discussed by the Supreme Court in one landmark decision. It's the DAV College Jalandhar versus State of Punjab. This case was decided in 1971. There is one legal provision which requires or which was requiring that Guru Nanak University is to promote the studies and research in Punjabi language and literature, and to undertake measures for the development of Punjabi language, literature, and culture. And it was challenged in this case, that is DAV College Jalandhar versus State of Punjab. Here, the Supreme Court emphasized, here the Supreme Court although says that it does not violate or infringe Article 29 Clause 1, as Supreme Court has emphasized that the purpose and object of the linguistic state, which now come to stay in India, is to provide greater facility for the development of the people of the area educationally, socially, and culturally in the regional language. The concerned state and university to provide for education of majority in regional medium. So this is, however, the Supreme Court has clarified. This is, however, subject to subject to restrictions contained under Article 25 to 30 of the Constitution, and all of you know that. In case if we again recall the restrictions for 25, that is subject to public order, morality, and health. So promotion of majority language does not mean stifling of the minority language. Means that the majority language cannot prevent the breathing of minority language in the pretense of the promotion of majority language or the language of the majority, or language of the language or script of the majority. So to do so will be to, and it will be, in case if it is going to be happen, it will be the trespass on the right of those sections of the citizens which have distinct language or script which they have right to conserve, and that right has been permitted under Article 29 Clause 1 of the Constitution, which talks about that any section of the citizens have right who are having distinct language, distinct language, script, or culture of its own, has the fundamental rights to conserve the same. This is, however, and here the Supreme Court held that the others have also have equal rights under Article 29, Clause 1 of the Constitution. The provision in question cannot therefore be requiring cannot therefore be raised as requiring minority institutions affiliated to university or Guru Nanak University to teach the Punjabi language. And that's why the Supreme Court also rejected the argument saying that there is no mandate in the provision for compelling affiliated colleges either to study the religious teaching of Guru Nanak or to adopt in any way the culture of Sikh religion. The affiliated college cannot require to study the compulsory life of Guru Nanak Dev and his teaching and teachings. Uh, I'm sorry that I will be coming back after only. Uh, as all of you know that we were discussing, sorry for interruption, we were discussing uh, the scope of Article 29 Clause 1, and the scope of Article 29 Clause 1 was discussed by the Supreme Court in DAV College, Jalandhar versus State of Punjab, as one legal provision requiring Guru Nanak Dev University to promote studies and research in Punjabi language and literature and to undertake measures for the development of Punjabi language, literature, and culture. And it was challenged by the DAV College, Jalandhar, that it is going to infringe their rights under Article 29, Clause 1, which permits to promote or to conserve their script or culture of its own. The Supreme Court held that it does not or it did not infringe Article 29, as Supreme Court has emphasized that the purpose and object of the linguistic state, which now come to stay in India, is to provide greater facility for the development of the people of the area educationally, socially, and culturally in the regional language. The concerned state and the university to provide for education of majority in regional medium. This is, however, the Supreme Court held that however, it is subject to the restrictions contained under Article 25 to 30 of the Constitution. Promotion of majority language does not mean stifling of the minority language or in the pretense or guise of the promotion of the majority language or culture does not permit the majority to prevent to prevent breathing of the minority. And here, if it is doing so, means that if the majority is behaving so, then it will be the trespass on the right of those sections of the citizens which have distinct language or culture or script, which they have equally right to conserve of its own through their own educational institutions and the or it means that the other citizens or sections of the citizens, they are also having right to promote or to conserve their language, script or culture as it has been guaranteed under Article 29, Clause 1 of the Constitution. The provision so in question or the provision which was challenged cannot therefore raised or cannot therefore asked as requiring minority institutions affiliated to Guru Nanak Dev University to teach in Punjabi language, which they cannot, although they cannot force or compel to other sections of the citizens to teach in Punjabi, although they have equally right to promote their language under Article 29 of the Constitution. Here the Supreme Court also rejected the argument saying that there is no mandate in this provision for compelling affiliated colleges either to study the religious teachings of Guru Nanak Dev or to adopt in any way the culture of Sikh. So the affiliated college cannot require to study compulsorily his life and his teaching and preaching. So we can say that Article 29 is having the scope for promoting to every section of the society to, to promote or to conserve his language, his script or culture. So there cannot be any kind of interference by the other sections of the society because it has been not conferred to particular religion or to particular community to promote their language, culture or a script. Now Article 29 Clause 2. Article 29 Clause 2 talks about the benefit. What's the benefit of Article 29? Why the Article 29 has been envisaged in our Constitution? Article 29 Clause 2 or the benefit of Article 29 Clause 2 is not confined only to the minority group, but it extends to all citizens, whether belonging to the majority or minority groups, in matter of admission to the educational institutions maintained or aided by the states. Here, Article 29, Clause 2, which talks about that educational institutions shall not make any kind of discrimination for giving admission to these any sections of the citizens in their educational institutions who are getting the getting or receiving the aid on the grounds of religion, race, caste, or language, or any of them. So, the scope of Article 29, Clause 2, the application of Article 29, Clause 2 arose first time in India, or arose first time after the commencement of Constitution in one landmark case. It was the case of State of Madras versus Champakam Doirajan. Dear students, in case if you are able to recall, this landmark judgment has been discussed under Article 15 of the Constitution, and all of you know that this article, the decision of this article, has given birth to Clause 4 of Article 15 of the Constitution. In reference or in context of the scope, Article 29, Clause 2, again we can recall the facts, we could recall the facts of the case of this landmark judgment, that one communal government order of the State of Madras, which allotted the seats in medical college and engineering college in the state proportionately to the several proportionate to the proportionate to the population, to the several non-Brahman Hindus, backward class Hindus, scheduled castes, Anglo-Indians, Christians, and Muslims. A Brahmin candidate who could not be admitted to the engineering college challenged the government order, being inconsistent, and challenged it on the and raised the contention that it is absolutely inconsistent with the provision of Article 29, Clause 2 and Article 15, Clause 1 of the Constitution. Here the Supreme Court held that classification in government order was based on religion, race, and caste, which was plainly inconsistent to Article 29, Clause 2. And even though the petitioner had scored much higher marks than those scored by many of non-Brahmins candidates who were admitted in seats allotted to them in engineering and medical college. And therefore, the Supreme Court struck down the provision, and that had led to the insertion of Article 15 Clause 4 by the first constitutional amendment of 1951, which made the provision for special provision for socially and educationally backward class or scheduled caste and scheduled tribe. Now, another case which talks about the scope of Article 29 Clause 2. The state of Bombay versus Bombay Education Society, and this case was decided by the Supreme Court in 1971. An order was issued by the government or government of Bombay banning admission of those whose language was not English to a school using English as medium of instructions was declared invalid under Article 29 Clause 2. So here, because that was violating Article 29, that's why the order which was asking to make the admission on the basis of purely on one language, that is English, was quashed and declared invalid. Now, what's the difference between Article 15 Clause 1 and Article 29 Clause 2? Article 15 Clause 1, as all of you know, protects all citizens against the discrimination by the state on the ground of religion, race, caste, or place of birth. Whereas Article 29 extends protection against the state or anybody else who denies the rights or who denies the admission in educational institutions. So Article 29 gives protection, although the Article 15 Clause 1 prohibits discrimination generally in all matters, whereas Article 29 Clause 2 gives, gives protection only species of wrong, namely denial of admission into the state aided or maintained educational institutions. Again, Article 51 prohibits the discrimination on more grounds, including sex or place of birth, as compared to Article 29 Clause 2. So we could say that Article 15 Clause 1, being broader in scope as compared to Article 29 Clause 2, which talks about the ground only religion, race, caste, and language. Now, difference between Article 15 Clause 4 and Article 29 Clause 2. Article 15 Clause 4 are, as all of you know, was added by the first constitutional amendment after Champakam Koirajan to ensure the advancement of socially and educationally backward class of citizens or SC/ST, but the fundamental rights guaranteed under by Article 29. talks about the discrimination, particularly on the particularly on the ground of religion, race, caste, and language. Now, Article 15, Clause 5 and Article 29, Clause 2. Article as one landmark decision, that is TMA5 Foundation, which was decided in 2002, which makes the distinction between aided and unaided educational institutions, that state cannot insist reservation on private institutions which receives no aid. And although I'll be discussing all these cases subsequent to the TMAPI, it was Islamic Academy case which cleared the doubts raised in TMAPI. Then it's again another landmark case, PA Namdar, which had overruled Islamic Academy, and because of the decision of or consequences of the decision of PA Inamdar, there was 93rd Constitutional Amendment which had given birth to Article 15 Clause 5, which I have got discussed earlier also, and the Article 15 of the Constitution. Now I am coming to another article, that is Article 30 Clause 1. Article 30 Clause 1 gives linguistic and religious two important fundamental rights to the linguistic and religious minority. That these linguistic and religious minority have a right to establish and administer the educational institution of their own choice. Article 30 Clause 1 extends the linguistic minority and religious minority. Here, one thing must be clear, that it's Article 30 Clause 1 extends only rights to the linguistic and religious minority to establish and administer their educational institution of their own choice, not any other sections of the citizens or sections of the Indian citizens. Now, Article 30 Clause 2, which bars the state while granting aid to the educational institution on the ground of that institution is under the management of linguistic or religious minority, means that Article 30 Clause 2 talks about or prohibits the states not to make any kind of distinction in granting of aid to the linguistic or religious minority educational institutions. So, Article 30 Clause 2 is mandates in granting aid to the educational institution, and it mandates that there shall not be any kind of discrimination in granting the aid by the state. That the Supreme Court has pointed out in one case, it's the case of Ahmedabad St. Xavier College versus State of Gujarat. It was the case of 1974 that the spirit behind Article 30 Clause 1 is the conscience of nation that the minorities, religious as well as linguistic, are not prohibited from establishing and administering educational institution of their choice for the purpose of giving the best general education to their children, to make them complete men and women of the country. In PMAPI also, the expression of educational institutions means education educations that impart the education, including education at all levels, from the primary schools, colleges, postgraduates, colleges, universities, and also the professional colleges. The minorities, the Supreme Court held that the minorities will feel isolated and separately if they are not given protection of Article 30. And that's why the provision under Article 25 to 30 preserve the fibers of secularism, as we have discussed that prior 42nd Amendment we had no explicit provision of secularism. We had implicit provision of secularism under Article 25 to 30 of the Constitution. Now, question arises: what is minority? So far as we discussed, Article 29, Clause 1, citizens have fundamental rights to conserve their language, script, and culture of its own. Article 29, Clause 2, no discrimination, no discrimination by educational institution in giving admission and which are receiving aid or maintained by the state on the ground of religion, race, caste, language, or any of them. And again, Article 30, Clause 1, the right to establish of educational institutions and right to administer of educational institutions of their own choice. Article 32, Article 30, Clause 2, states are prohibited to make discrimination while granting aid to the minority educational institutions. Now, from the above provisions, which has been discussed in various in articles 29 and 30, we can summarize that there may be four types of education institutions in addition to purely government education institutions which are run by the state government either at the school level or the college level or the university level. But now question arises, what are all of those four important education institutions which can be summarized under Article 29 in the light of Article 29 and 30 of the Constitution. First, the educational institutions of non-minority which are receiving the aid from the government. Second, educational institutions non-minority which are also known as private unaided institutions because they are not getting aid from the government. Third, the educational institutions run by the minority but they are receiving the aid from the state government. Fourth, educational institutions run by the minority but not receiving any aid from the state government. Now, in the light of Article 29 and 30 and various education institutions which are run by the minority or non-minority raises the issues or raises rather the various issues which had been raised or which has been raised and is being raised and may be raised in future related to these educational institutions, including primary schools, high schools, high or secondary schools, colleges, related to the universities or professional colleges, including engineering colleges and medical colleges. Now, what are the issues? First, we can share that issues related to the Article 30 Clause 1, which empowers the minority, to establish and administer educational institution of their choice. The question is there whether the minority has the absolute right to establish and administer their educational institutions of their own choice. So the question arises whether next question arises whether the government has any control over the minority education institutions which are imparting education without observing fair, transparent, and non-exploitative norms in running of their education institutions. Means that in case if the minority education institution in pretense of the right under Article 30 clause 1, they are running their education institutions according to their own choice and not observing the essentials norms which are meant for the interests of this nation, that is the interest of fairness, transparency, and non-exploitation. Now here, first of all, in case if we talk about these two types of education institutions, especially the minority education institutions. The first is receiving the aid from the government. Another, minority education institutions which is not receiving any aid from the government, which is to be known as minority unaided education institutions. Another question can be raised related to the non-minority education institutions. Again, here is also two types of education institutions which could be covered under the heading of non-minority education institutions, that is non-minority education institutions which are getting the aid or receiving the aid, and non-minority education institutions which are not getting the aid or receiving the aid, which are known as purely private educational institutions which are run by the non-minority groups. So the important issues had been in controversy related to the education institutions. First, related to the education institutions, what is that important issue or important questions which had been raised and which has been raised and which is being raised. What is that issue? Does government regulate those educational institutions, that is minority aided institutions, minority unaided institutions, non-minority aided and non-minority aided institutions, and non-minority unaided educational institutions regarding admission of students, the issue regarding admission of students to educational institutions according to their own choice or of their own choice. Second, administration in their education institutions of their own choice, especially related to the recruitment of teachers, other staffs, their qualifications, their salaries of their own choice. Then other important issue, the standard of education of their own choice, or they bound to impart the quality of standard of education according to the norms prescribed by the government. And most important issue that relates to the fixation of fee structure. The most important issue now that relates to the fixation of fee structure, whether minority educational institutions, minority aided, minority unaided educational institutions have been empowered to prescribe the fee structure of their own choice, and the non-minority like that, non-minority educational institutions, aided or unaided, are having power or have been empowered to prescribe the fee structure of their own choice. So the question of quantum of students also, the admission of quantum of students. So what does it mean? That in minority educational institutions, what does it mean? Whether minority aided educational institution of their own choice without any regulated measures, whether or the fee structure of minority aided educational institution of their choice without any regulatory measures. So again, we can share that all these issues are again and again, that all these issues has been raised by the society, which are related to non-minority educational, non-minority aided and unaided educational institutions, and minority aided and unaided educational institutions. So all these issues are related in the light of another most important provision of Constitution, that is to be covered under Article 19 clause 1 clause G of the Constitution. Because as and when the government has tried to regulate or to manage all these issues, arisen issues time to time, the educational institutions of minority raised the protection of fundamental rights under Article 30 of the Constitution, and non-minority raised the protection of Article 19 clause 1 clause G of the Constitution, which guarantees article as all of you aware that Article 19 clause 1 clause G gives guarantee for fundamental rights of trade, business and profession, etc. So, above said issue has been dealt by the courts in many landmark judgments, time to time, especially. Although we are not able to cite all those landmark judgments, but the few judgments which can be cited, especially Kerala Education Bill. Kerala Education Bill, which decided the issues related to educational institutions covered under Article 30. And in this case, it was the Supreme Court which held that fundamental rights of the minority unaided to establish and administer educational institution of their choice militate against the claim of the state to insist that granting of aid state may not prescribe reasonable regulation to ensure the excellence of education institution. However, the condition for aid should not be imposed so as to infringe fundamental rights of minority under Article 30 Clause 1. This means that the minority unaided institutions could not prevent the claim of the state government for the purpose of regulating the affairs of minority educational institutions in the pretense of Article 30 Clause 1. Although the state government also should not be imposed such kind of conditions, such kind of regulatory measures so as to become a tool for infringement of fundamental rights of minority or infringement of Article 30 Clause 1. The second case, that is St. Stephen College versus Delhi University. It was the case of 1992. In this case, the validity of admission program and performa given by the university or by the, first of all, given by the Christian educational institution, that is St. Stephen, that they will be making a preference in admission to the Christian students because they will be conducting one interview for the purpose of making the admission in their minority education institution, that is St. Stephen College, which is affiliated to Delhi University. Now it was challenged as the violative of Delhi University circular, which was meant for the admission of BA and BCom program in the session of 1980 and 81. It was the St. Stephen College published prospectus, as I got mentioned. It was mentioned that there would be interview prior to final selection. Delhi University, by its circular issued on 5th of June and 9th of June 1980, issued circulars to all affiliated colleges that admission will be based on pure merit of marks of qualifying examinations. Here the Supreme Court by majority 4-1 held that college is not bound by the circular, as it will deprive the college of their minority character, because the impugned circular would deny the right of college to admit the students of Christian community, minority aided institutions may preserve 50% seat for their community students and are entitled to give preference in admission as it is necessary to maintain or protect right under Article 30, Clause 1. Admission of other community candidates will be done on pure merit. Now, another important case law which was decided by the Supreme Court, that is also very important case law. It's the Unni Krishnan versus State of Andhra Pradesh, which was decided in 1993. In Unni Krishnan case, the Supreme Court, which had prescribed the fee structure to be charged by the non-minority unaided institutions and aided education institutions conducting the professional courses such as engineering and medical courses, etc. But such fee would not be exercised. The maximum limit fixed by the state government. And it was also held that commercialization of the education is not permissible. And right to education was a fundamental right, especially in the light of Article 45 and Article 37 of the Constitution. Here, I don't skip to mention that it was the case in which the Supreme Court first time held that right to education is not a simple right. It's a fundamental right in the light of Article 45 of the Constitution, and this decision has led to amend the Constitution by 86 Constitution amendments, which inserted Article 21A, which guaranteed for right to education. The Article 21A of the Constitution. Now, another important, rather very important landmark decision, that is TMA Pi Foundation versus State of Karnataka. This decision had a far-reaching results, far-reaching consequences, because this decision had decided by a larger bench so far, and it was decided by 11 judges of the Supreme Court, and it was decided by the majority of 7 to 4. Here it was Justice or Chief Justice of India, Justice B.N. Kripal, on the behalf of majority decision. The 6 judges included one judge opinion concurring with the majority decision. Remaining 4 judges gave 3 separate opinions in which they dissented from the majority opinion. This decision tackled the various issues which I have got discussed, related to especially the minority aided educational institutions and unaided education institutions, non-minority aided institutions and unaided educational institutions. First of all, and this decision lays down various guidelines for the purpose of regulating the establishment of educational institutions and administration of educational institutions run by the minority or by the non-minority. The first issue which was settled by this majority decision, that who is minority? What is minority? Here the Supreme Court held that with regard to a state law, the unit to determine a religious or linguistic minority can only be the state. And even for central law, for the purpose of determining the minority, the unit will be the state and not the whole of India. Therefore, the religious and linguistic minorities who have been put on a par under Article 30 have to be considered state-wise, even despite of the fact they are having a central law. Next issue, the minorities, the next guideline, minorities rights under Article 30 clause 1 covers professional education as indicated by the use of the words of their choice. Any regulations framed in the national interests must necessarily apply to all educational institutions, whether run by the minority or by the non-minority or by the majority. Such limitation must necessarily be read into Article 30. So the right under Article 30 clause 1 cannot be such as to override the national interest or to prevent the government from framing regulations in this behalf or in that behalf. But it is, of course, true that government regulations cannot destroy the minority character of the institutions or make the right to establish and administer a mere illusion or myth. But the right under Article 30 is not so absolute as to be above the law of the land. Here, I must share the Supreme Court observed the observation made in Kerala Bill case. Next guideline, that even the words of Article 30 clause 1 are unqualified, at least certain other laws of the land pertaining to health, morality, and standard of education would be applied, may be applied. As we discussed earlier, that under, although the rights or fundamental rights under Article 25 and 26 are subject to public order, morality, and health, etc. But under Article 30 clause 1, which talks about or which gives the words of Article 30 clause 1 are unqualified, but certain laws of lands pertaining to health, morality, and standard of education may be applied. The right under Article 30 Clause 1 is not absolute or above other provisions of the law, regulations, or conditions concerning generally the welfare of the students and the teachers may be applicable, may be equally important in order to provide a proper academic atmosphere, good academic atmosphere, conducive academic atmosphere, as such provisions do not in any way disturb or interfere or make any impediments with the right of administration or management under Article 30 Clause 1. Article 30 Clause 2 only means that minority institutions, educational institutions, shall not be discriminated against where aid to education institution is granted. If an abject surrender of the right to management is made a condition of aid, the denial of aid would be the violation of Article 30 Clause 2. However, condition of aid that do not involve a surrender of the substantial right of management would not be inconsistent with the constitutional guaranteed under Article 30 Clause 2. So even if the directly impedes upon some facet of administration, the implications of Article 30 Clause 2 is also that it recognizes that minority nature of an institution should continue notwithstanding of the grant of it. Next important guidelines that although the right to administer includes within the right to grant admission to their students of their own choice under Article 30 Clause 1. When such a minority institution is granted the facility of receiving grant in aid, Article 29 Clause 2 would apply. Means that the as and when the minority institution is receiving the aids, then Article 29 Clause 2 would apply. And necessarily, therefore, one of the right of administration of the minority would be infringed to some extent as long as the minority educational institution permits admission of citizens belonging to the non-minority class to the reasonable extent based on merit. It will not be an infraction or violation of Article 29 Clause 2. Even though the institution admits students of the minority group of its own choice for whom the institution was meant. Now, what would be the reasonable extent, it would be depend upon the variable factors, and it may not be advisable to fix any specific percentage. The situations would vary according to the types of institutions and the nature of educations and is being imparted in the institutions. Even if it is possible to fill up all the seats with the students of minority group, the moment of institution is granted age, the institution will have to admit the students of non-minority group, non-minority group to a reasonable extent, observing that a ceiling of 50% would not be proper. The Supreme Court held that it will be more appropriate that, depending upon the level of institution, whether it is primary school or secondary school or high school or college or university or professional college, including engineering college, medical college, etc., or otherwise, and on the basis of population and education and educational needs of the area in which the education institution is situated or located. The state properly, the state government must properly balances the interest of all, providing for such a percentage of students of the minority community to be admitted as to adequately serve the interests of the minority community for which the institution was established. For unaided schools, undergraduate colleges, where scope of merit based selection is practically nil, state or university can provide qualifications and minimum eligibility conditions. Means here here the Supreme Court regarding the unaided schools and undergraduate colleges advise that the minority unaided schools and undergraduate colleges, they could admit the students according to their choice, as scope for merit sometimes becomes difficult, but admission admission to the state or university can provide for a qualification and minimum eligibility condition. Admission has to be on a transparent basis and merit considered. Another important guideline: right to administer is not absolute, and so regulatory measures can be imposed for ensuring educational standards and maintaining excellence thereof, especially in professional institutions or professional educational institutions. The next important guideline: an aided minority institutions remain so despite receiving aid from the government. It has a right over the admitting its minority students on merit basis. It must also admit a reasonable number of non-minority students. What is reasonable number is to be decided by the state government in case of the aided minority educational institutions, and it will be decided by the government on the consideration of the, again, type of institutions, whether it is primary school, secondary schools, or professional college, and the courses of education, and the population and educational needs of the minority. The rights of minorities includes right to determine the procedure and methods of the admission and selection of students must be fair, transparent, and based on merit for professional and higher education colleges. Even unaided minority education institutions cannot ignore the merits. In case of aided institution for non-minority students, the state can regulate the admission, which has to be merit-based, subject to little reservations policy of the state. Merit to be determined by an entrance test or by any other method with consideration for weaker section. In case of unaided minority institutions, the regulatory measures of control by the states should be minimal, though conditions of recognition and affiliation has to be complied with, and though matter of appointment of teaching and non-teaching staff and administrative control over them would be beyond the regulation. Fee charged by unaided institutions cannot be regulated. Fee charged by unaided minority educational institutions cannot be regulated, but they cannot charge capitation fee. In case of aided minority institutions, regulation can be provided for conditions of service of teachings and other staffs without interfering with the overall administrative control. But both in aided and unaided minority institutions, management must evolve a rational procedure for selection of teaching staff and for taking a disciplinary actions. State or controlling authority can always prescribe the minimum qualifications, experience, and other conditions bearing on the merit of an individual for being appointed as a teacher or principal of any educational institution. So, in this landmark judgment, we could conclude that the Supreme Court has overruled the ruling or ratio of St. Stephen College decisions, the judgment of St. Stephen College, and Unni Krishna relating to the grant of admission and fixings of fee structure was held not correct. Means that DMFI fixing of fee structure by the state in Unikirsan was not found correct as per the version of or as per the ratio of DMFI. And that's why to that extent that is overruled. Such educational institution now may charge such fee as is required for betterment and growth of education institution, but they should not be there should not be any element of profiteering in fixing of the fee structure. Where the Supreme Court also overruled the decision of St. Stephen, where it was held that minority education institutions were free to reserve seats up to 50% for their minority students. Now the court empowered the states to fix the quotas for minority students, taking account the types of education or types of the educational institutions, population of minority, and educational needs of the minority. So, dear students, it was one of the landmark judgment. Although it was one of the landmark judgment, but after pronouncements of this judgment, it has created various doubts because of the different interpretation taken by the various high courts of the country. And all those doubts or interpretation or ambiguous interpretation was resolved by the Supreme Court in subsequent decision. It was the decision of Islamic Academy case, which I would like to discuss in my next lecture. And again, I am making here request that in case if you feel any kind of difficulty or doubts, then kindly ask your CR or ask Mr. Khan from A sections or the students from A section, they may ask to Mr. Maan, and students from J section may ask to Mr. Abhishek Agarwal to arrange a discussion on Zoom or video conferencing for resolving, for removing all kind of doubts or any kind of ambiguities from so far delivered lectures through these videos. Here, dear students, all of us are facing a big crisis because of natural disaster. So kindly go through the various good books and your case material. Good books like MP Jain, Jain Pandey, VN Shukla, etc. and your case material for the purpose of preparation of your examination, coming examination. So thank you, thank you. Yes, in case because in this lecture, because of little bit technical fault in net or technical fault because of otherwise you have been interrupted. So I sincerely regret for discontinuing my lecture and continuing my lecture. Thank you.